Hello everyone. Welcome to Law Simple, Pure and to the Core. Dr. Vaishali here. Today's lecture is lecture number 1 in our series of 10 lectures. It's about question number 1. What is jurisprudence, or meaning, nature, definition and scope of jurisprudence, or kinds of jurisprudence. So let us begin. We are going to learn jurisprudence in its pure form. We'll start with introduction, or what is jurisprudence, what are the types of jurisprudence. Then we'll go through why we study jurisprudence, or the practical utility or function of jurisprudence. Then we'll study what is there in jurisprudence, means scope of jurisprudence or subject matter of the jurisprudence. Then we'll go through various definitions provided by various jurists on jurisprudence. And then we'll have a brief review of various schools in jurisprudence. In simple words, jurisprudence is called as science of law or philosophy of law. Jurisprudence is derived from Latin word jurisprudentia. Juris means law and prudentia means knowledge. So jurisprudence is nothing but knowledge of law. In the words of Carl Levlin, jurisprudence is as big as law and even bigger. Let us understand meaning of this statement so as to understand jurisprudence in a better way. As we all know, law is a living growth. Law keeps changing, law keeps evolving, law keeps trying to accommodate the needs of changing society. That evolution, that growth, that enrichment of law is condensed in jurisprudence. Again, approaches of jurists at various times and places about nature, source, and various concepts in law is condensed in jurisprudence. Its enrichment of the concept of law itself. In this sense, it covers the whole body of legal principles in the world. The history of the concept of law reveals that jurisprudence has assumed different meanings at different times. Hence, it's difficult to attempt a singular definition of the term, and that's why there are so many definitions of jurisprudence which we are going to discuss in this lecture. It has a long history of evolution, beginning from classical Greek period to 21st century modern jurisprudence, with numerous changes in its nature in various stages of its evolution. So in short, jurisprudence has an origin traceable back to Greek period, but it is still growing and evolving. There are certain types of jurisprudence which are coined for the sake of understanding jurisprudence better. However, the general jurisprudence can be divided into two categories, which include the analytic jurisprudence and normative jurisprudence. The analytic jurisprudence talks about the questions as to what is law, while the normative jurisprudence talks about questions such as what is the purpose of the law. So analytical jurisprudence is about what is law in reality, and the normative is about what is the purpose of law. So these are two types of jurisprudence. Bentham differentiated between studies of law as it is and as it ought to be, and called them expositorial and censorial jurisprudence respectively. So a jurisprudence which studies law as it is called expositorial jurisprudence, and jurisprudence which studies law as it ought to be is called as censorial jurisprudence. There are several schools of jurisprudence: philosophical, positive, historical, comparative, sociological. They do not represent different avenues or approach to a common goal, but rather different goals. They differ as to what jurisprudence is. It is a science, a philosophy, a general attitude, a system, a theory, or a method as per these different schools. Changes in jurisprudence conditioned by changes in law, hence theories keeps changing and developing. In question paper, sometimes a question will be asked about scope of jurisprudence, or nature and scope of jurisprudence, or about the subject matter of jurisprudence. So let us understand. Jurisprudence involves certain type of investigation into law, an investigation of an abstract, general, and theoretical in nature, which seeks to lay bare the essential principles of law and legal systems. So it is certain investigation into a law, but not a normal investigation, a theoretical type of investigation about its origin, about its development, about certain concepts and their enrichment. So it is a theoretical discussion about law. Elaborating the point further, Salmond observed, in jurisprudence, we are not concerned to derive rules from authority and apply them to problem. We are concerned rather to reflect on nature of legal rules, on the underlying meaning of legal concepts, and on the essential features of legal system. This makes the distinction between law and jurisprudence aptly clear. I'll give you an example to make my point clear. There are two laws, a criminal law and jurisprudence. In criminal law, what we do, if a crime is committed, that specific section is applicable, right? So a certain provision is there which is applicable in certain condition. But jurisprudence is more general in nature. It is more abstract. What we do in jurisprudence, we study about that rule, like why this type of rule is there in criminal law, how it is developed, right? So it is investigation into law, not any specific type of law, but law in general. The scope of jurisprudence is not limited to the study of one or few legal systems. It relates to comparative study of different legal systems, suggesting codification and legal reforms through legislation. Jurisprudence poses the fundamental question about the nature of law, its place in society, and how a legal system operates as a system of rules, as a social institution, engaging with ideals of justice and often conflicting moral codes. So jurisprudence is more abstract, it's more investigative type of study into law itself, into the concept of law itself, and that is the difference between a normal law subject and jurisprudence. It is an investigation into law, into theories of law. So jurisprudence is more theoretical in nature. In simple words, we can say that jurisprudence is the name given to a certain type of investigation into law, but the investigation of an abstract, general, and theoretical nature, which try to find essential principles of law and legal systems. According to Oxford Dictionary, it is defined as systematic and formulated knowledge or science of human law. Eulapian defined jurisprudence as the observation of things, human and divine, the knowledge of just and the unjust. As per Gray, jurisprudence is the science of law, the statement and systematic arrangement of the rules followed by the courts and the principles involved in those rules. As per Salmond, the science of the first principles of the civil law. Thus he points out that jurisprudence deals with particular species of law, namely civil law or the law of the state. Keaton defines jurisprudence is the study and systematic arrangement of the general principles of law. The definition seeks to explain the distinction between public and private laws. As per Roscoe Pound, jurisprudence is the science of law using the term law in the juridical sense, as denoting the body of principles recognized or enforced by public and regular tribunals in the administration of justice. As per Justice P.B. Mukherjee, jurisprudence is both an intellectual and idealistic abstraction as well as behavioral study of man in society. It includes political, social, economic, and cultural ideas. It covers the study of man in relation to state and society. Austin calls jurisprudence as the philosophy of positive law. Sir Thomas Holland defines jurisprudence as the formal science of positive law. After all these definitions, you can sum up your own definition, like jurisprudence is the science of law. It is about the origin, growth, development, and enrichment of the concept of law itself. So you can give your own definition of jurisprudence as per your understanding. Now the scope or the subject matter or content of jurisprudence. What is there in jurisprudence? The nature and definition of the subject is there. Then various schools about law are there in jurisprudence. Various concepts like ownership, right, liability, custom, precedent, and so on. These concepts are studied in detail in jurisprudence, and then comparison of various schools and movements and critical evaluation of the same is provided in the jurisprudence. So jurisprudence is everything about the law and various concepts involved in law. Now your approach while studying or writing your answer. Every law student should always remember that there are two types of subjects. One are types of law and the others are law subjects. Types of law means a subject which relates to a specific law. For example, criminal law in your country, or law of contract or company law in your country. So it is a specific law dealing with a specific situation. But apart from these types of law subjects, there are certain law subjects. Law subjects are more type of theoretical subject like criminology. Criminology speaks about the concept of crime, about the criminals, about the various theories of criminal behavior, various theories of origin of criminal behavior, and so on. So it's not just about crime. About crime, there are so many criminal laws, but criminology is about the entire criminal law, about the origin, about the growth, about the development and enrichment of criminal law itself is there in criminology. Interpretation of statute, like how you will interpret a particular law, those rules are pretty much universal. Those rules, international law, human rights, jurisprudence, or the legal maxims, these are universal kind of subjects. Usually law students take these subjects lightly, but do not do that. Try to understand these subjects, because these subjects explain something beyond statute. They go beyond the statute, and then they make you capable lawyer or capable judge who knows something beyond the statute, who knows the base of law. If you know base, interpretation goes at a different height, because there are multiple interpretations of the same concepts, and if you know those multiple interpretation, you can use an interpretation which best serves your purpose. And in jurisprudence, there is comparative content provided, which always helps. So theory helps to improve practice. So jurisprudence helps you to become a better lawyer or a better judge or a better teacher. There are certain vague concepts like justice, equity, and good conscience. You understand these concepts with the help of jurisprudence. Example, concept of liability. That concept is crystallized from individual cases to a general rule. So that comparative analysis of that concept of liberty itself, commentary on it, it is condensed in jurisprudence, and that's why it always helps a lawyer. Then comes various schools in jurisprudence. Before learning these schools in jurisprudence, you should remember certain things. These schools are not made at a certain time, or they were not written like this is a natural law school, this is a positivism, this is historical jurisprudence and all. These schools are evolved over a span of centuries by different jurists, and then they are condensed in jurisprudence and collectively called as different schools. So if philosophy of jurist goes along with natural law's central idea, then he is a natural lawyer, that type of inclusion. So they are developed over a span of centuries by different jurists and different philosophers. Second things, sometimes one school came sometimes one school came as a reaction to other school. There is a historical link between these schools, and some of them are contemporary, some are reaction, and some are simply synthesis of two or more schools. There are different names, sometimes they are confusing, and we will try to solve this confusion by referring all the other alternative names as well. Now let us quickly go through the different schools before understanding them one by one in detail. Law is made by nature or divine rule. It's called as philosophical school or natural law school. Central theme revolves around ethics and morals and reason. So natural law theory revolves around ethics and morals and the reason, but the reason is a higher reason or a moral reason. Aristotle, Plato, Grotius, Immanuel Kant, Hegel, Locke, Hobbes and Rousseau, these are the natural law jurists. After natural law school came historical school, and which believes that but law is not made by nature, but it is found in historical development. And Savigny, Henry Maine, and Puchta, they are the lawyers from this school of law. Then third school is about man-made law, which is called as positivism. Law is divorced from moral and all the non-legal factors in this school. It is also called as analytical school, also known as imperative school or the Austinian school. It is likewise called as an imperative school since it regards law as the direction of the sovereign. Bentham, Austin, Kelsen, and Hart, they are the philosophers from this school. Social interaction made law is also called as sociological jurisprudence. It is a synthesis of positivism and historical jurisprudence. Montesquieu, Auguste Comte, Herbert Spencer, Duguid, and Roscoe Pound are the philosophers from this school. As per this school, law is made as well as it is found, but where? In the social interactions. So law is made, that is a fact, it is found, it is also a fact, but where? In the social interaction between people. Then comes realism, which believes that judges make law. The school focuses on the judgments of the authority, judges and their mindset. John Gray and Oliver Wendell Holmes and some other jurists belong to this school. Jeremy Frank and Levlin also belong to this school. Afterwards, there are certain other movements like Marxism, critical legal studies, and feminist jurisprudence. Central theme of Marxism is law is an instrument used by ruling class to keep the working class in control. It is a tool of exploitation. So, see, every school has a central idea or theme, and the school, all the jurists from that school, they keep revolving around that central idea. In case of natural law, it revolves around ethics and morality and higher reason. In case of historical school, it keeps developing around history or the historical source of law. How law is naturally found in historical developments is the central theme. In positivism, it rotates around man-made law. In case of sociological jurisprudence, the central theme is social interaction giving birth to law. In case of realism, the central idea is about judgment law. So every school has a central idea. If we know that, we can develop that school further. Now in the next lecture, we are going to see natural law school in detail and all the developments in that school from ancient to modern period, and we are going to refer all the jurists from the school. That's it for the day. Stay tuned for the next lecture, which is going to be on natural law school. In 10 lectures, you can learn entire jurisprudence with a crystal clear understanding. Try to understand the central theme of each school and then one by one try to understand various jurists from the same school. So it is quite easy. We are going to learn everything in detail. Stay tuned till my next lecture. Goodbye and good luck.